Hi, today I'm going to be talking about fraud and wills. It's often an allegation that's thrown about that a will is not valid because it's either been fraudulently put together or the signatures are forgeries. Whilst clients often throw these allegations around, a successful case is extremely rare. The reason for that is ordinarily in any civil case, it's on what we call the balance of probabilities. So that means if you succeed with, I don't know, showing 50.1% prospects of success, you'll win. However, when you're pleading fraud, the bar is a lot higher. Also, if you're alleging that the deceased signature has been forged, it often brings into question the witnesses as to whether they were party to the forgery, all sorts of questions as to who benefits from the estate. And like I say, it's extremely rare to the extent that over the last 100 or so years, there's only been about 5 cases that have actually succeeded with showing that fraud has taken place. Another claim that potentially comes under fraud, and that's what we call fraudulent calumny, is whereby a third person, often the person that benefits through the will, has drip-fed what we call poison over the years to the deceased, essentially telling them lies about family members or beneficiaries, to the extent that those beneficiaries then don't benefit at all in the will. Again, the bar is extremely high, and again, it's extremely difficult to succeed with such a claim. I've recently been involved in a High Court action called Wehash and Dennis in June 2023, which was in all the national newspapers, whereby we pleaded that the deceased didn't have capacity, but in the alternative that the gentleman, Justin Dennis, had committed fraudulent calumny in the sense that he had drip-fed his mother, the deceased, over a long period of time, that all the other beneficiaries had conspired together to defraud him out of the will. Now, this was clearly, from our client's perspective, not correct. However, when it went in front of the court, the judge came to the conclusion that the deceased lacked the capacity to make a will and found that the will was not valid on that ground, but would not accept that fraudulent calumny had taken place. Again, it's an example of the hurdle being so high that it's extremely difficult to succeed with it. If clients do wish to go ahead with fraud, ultimately, and they're absolutely adamant that signature is a forgery, the first steps to undertake are to get at least 10 to 15 possibly original signatures of the deceased. But if you can't get originals, get photocopies of signatures in and around the time that the forgery allegedly took place. These will then be sent off to a forensic handwriting expert who will then come to a conclusion, having produced a report as to whether the signature is valid. In this country, there is only a handful of forensic handwriting experts that give evidence in contentious probate matters in the courts, and therefore it is extremely important to get the correct expert very early on in order to look at whether fraud or fraudulent calumny has taken place. I hope this assists. It's an overview of what the law is. The law can get quite complex in this area, and there are lots of cases on it, but as I say, there are very few that have succeeded. Thank you.